So, in this class, we would like to discuss and start from question number 6 relating to Prevention of Food Adulteration Act 1954. So, question number 6 is, can a sanitary inspector be a competent and independent witness? And as per the question, the answer that we would found exactly under section 10, subsection 7 of the Act, and in connection to that also you would like to discuss an important leading case, and that is State of Punjab versus Raman Kumar in 1998, which was decided by the Punjab and Haryana High Court. So under subsection 7 of section 10, the food inspector shall call one or more persons to be present at the time of taking of sample, even though there is no statutory requirement that such witnesses should be independent, respectable, or of the locality, at the purpose of inspiring the confidence of the court. The witnesses called must be above board and independent and respectable. So, in the leading case, State of Punjab versus Raman Kumar in 1998, the Punjab and Haryana High Court held that by the relevant date, the PW1 was the food inspector attached to CDRO's office, and PW3 was the sanitary inspector attached to public health center. So it cannot be said that PW3 is not an independent witness and he is susceptible to the influence of the food inspector. Hence, the very fact that on being called by PW1 and PW3 accompanied him to the shop of the accused and was present at the time of taking of the sample is sufficient compliance with the provisions of section 10 subsection 7 of the Act. PW1 stated on oath that before the collection of the samples he approached the present at the spot of making them witnesses in the case, but all of them refused to be without disclosing their identity. There is nothing in the evidence of PW1 to disbelieve his sworn testimony that he made all honest attempts to procure the attendance of local witnesses at the time of taking the sample. So now we'll go to question number 7. That is, do you think the certificate issued by the director of Central Food Laboratory supersedes the report of the public analyst? And if so, then cite a case study. And as regarding the appropriate answer that we found under the provisions of section 13 subsection 3 and section 2 clause B and subsection 2 of section 2, and in relating to that we would like to discuss an important leading case, that is Din Dayal Gupta versus State of Rajasthan, which was decided in 1992 by the Rajasthan High Court. So, under Section 13, subsection 3 of the Prevention of Food Adulteration Act 1954, the certificate issued by the Director of Central Food Laboratory under Section 2 Clause B supersedes the report given by the public analyst under subsection 2. In this view of the matter, we have to discuss this leading case. Din Dayal Gupta versus State of Rajasthan, that when the director of the Central Food Laboratory, Ghaziabad, in its report dated 26 January 1980, had opined that the sample is considered as not adulterated, and the reasoning explaining the same is also been given for the excess percentage of free fatty acid as oleic that it could increase between the date of the withdrawal of the sample and its final analysis in this laboratory. The report of public analyst dated 2nd August 1978 stands superseded, and there is no reason for not authorizing adhering to the certificate issued by the Director, Central Food Laboratory, Ghaziabad. Thus, the sample had been considered as not adulterated by the Director, Central Food Laboratory, and as such, there was no basis for recording the finding of conviction against the petitioner. And in this connection, we would like to discuss another important leading case, and that is Rameshwar Dayal versus State of UP, and it was a case of 1996 decided by the Supreme Court. In Rameshwar Dayal versus State of UP in 1996, the Apex Court made the following observation on the scope of subsection 2 of section 13 of the Act. As decided by our Apex Court, section 13 subsection 2 nowhere says that the food inspector should indicate in his evidence as to who the local health authority prescribed by the central government or state government. All that section 13 subsection 2 requires is that on receipt of the report of the analyst to the effect that the article of food is adulterated, the local health authority, after the institution of the prosecution against the person from whom the sample of food was taken, should forward a copy of the report of the analyst to such person. So now we'll go to our next question, and that is question number 8. In which circumstance an accused under the Prevention of Food Adulteration Act may derive the scope of Article 21 of the Constitution of India? And in that connection, we would like to discuss one of the most important leading cases relating to this particular question is Vijay Kumar versus State of Haryana, and it was a case of 1997 decided by the Punjab and Haryana High Court. So it is well settled that the right to speedy and expeditious trial is one of the most valuable and cherished rights guaranteed under the Constitution. Fundamental rights are not a teasing illusion to be mocked at. These are meant to be enforced and made a reality. Fair, just, and reasonable procedure implicit in Article 21 of the Constitution creates a right in the accused to be tried speedily. Right to speedy trial is a right following from Article 21 encompasses all the stages, namely the stage of investigation, inquiry, trial, appeal, revision, and retrial. This is how the court shall understand this right and have gone to the extent of quashing the persecution after inordinate delay in concluding the trial of an accused, keeping in view the facts and circumstances of the case. So, in the very leading case, Vijay Kumar versus State of Haryana, in 1997, the Punjab and Haryana High Court held that keeping a person in suspended animation for 8 years or more without any cause at all cannot be with the spirit of the procedure established by law. It is correct that although minimum sentence to be imposed upon a convict is prescribed by the statutes, yet keeping in view the provisions of Article 21 of the Constitution of India, the interpretation thereof, the right of an accused to a speedy trial, judicial compassion can play a role and a convict can be compensated for the mental agony which he undergoes on account of protracted trial due to the fault of the prosecution. So, in this connection, we found that the provisions of Article 21 of the Constitution of India are quite relevant in relation to Food Adulteration Act, and it specially deals with speedy trial, and that trial exactly as prescribed, and it must followed by the procedure established by law. So now we'll go to our next question, that is question number 9. Under what circumstances can an accused under the Prevention of Food Adulteration Act, given the benefit of doubt, discuss and citing decided cases? So, in that connection, we would like to discuss some important leading cases like Sarmal Jain versus Nagar Nigam in 1996 by the Supreme Court, and another one is Keshav Ram versus State of Madhya Pradesh in 1996 by the Madhya Pradesh High Court, and Ram Vishal versus State of UP in 1996, it is also decided by the Allahabad High Court. So these questions, answers of this question we would like to discuss in our upcoming video.